Yes, sir.
मेरा वो करते हैं
अनम्यूट है सर आप।
अनम्यूट है कहाँ है
अनम्यूट
10 o'clock आपका शुरू हो जाएगा 10 o'clock
ये सबसे पहले पॉइंट
नहीं सर, ये कब से है मैंने?
Mr. Anil
राइट, यस मैम।
unmuted
यस मैम।
हमारी आवाज हो रही है broadcast में
नहीं अब ठीक है अभी 1 मिनट है ना
यस सर।
जो म्यूट करना होगा यही है ना
यस।
Good morning, everyone. Compassionary of family court judges, and even those who are likely to be part of the family courts in future. I extend a very warm welcome to this 2 days family court workshop, which would be carried through 8 different sessions over these 2 days as such. The Family Courts Act of 1984 was brought in with certain purposes, objects to be carried out. The settlement of family disputes through the medium of conciliation, mediation, was the main object. The speedy trial was another object of this particular legislation. Technicalities of the procedure and other aspects were not to be integral part of this legislation. Flexibility in that process. This legislation took time to really come into actual operation. I recall that it was in the year 1992 that the state of Haryana constituted the family courts. It was in the year 2013 that the state of Punjab, with a notification, came forward for the family courts. And 2 years later, Chandigarh also came with a notification for the constitution of the family court, which shows that it took time to really come into action for that matter. The same was the situation in different other states across the country. The real challenge of the family courts, to my mind, is building up happy homes, happy families, happy children. This indeed is a big challenge. And therefore, the responsibility cast on the family courts is a responsibility, an obligation to really effectively carry that out in that particular process. The second aspect, because on this particular background, the real growth of the nation, the human resource development depends. And therefore, my real purpose of this particular workshop is how best we can contribute in building up happy homes, happy families, and happy children. The second aspect, to my mind, the challenge is that family law in the domain of personal laws, but it is not diverse from public law. Even choosing a partner is not something personal in that sense. The right to personal liberty under Article 21 of the Constitution is playing a role of its own kind. And therefore, the elements of something which is reasonable, what is just and fair, is also integral to personal laws. And therefore, this mixing, blending of the two aspects is very significant. And therefore, I urge this morning, in introducing this particular theme of the family courts, that the family court judges would work in this particular direction so that we are able to build up healthy family jurisprudence as such. The first session is dedicated to understanding the family law, an overview of the Family Courts Act. And to deal with this important aspect, we have two stalwarts of the family courts, Madam Ritu Tagore and Madam Sangeeta Rai Sachdeva. They bring in such a rich experience, particularly in the field of family courts. They have contributed immensely. The richness of their experience would certainly be the guiding factor this morning in understanding this particular legislation. They are sharing this particular session, and I'm sure this session is going to be wholesome and meaningful. I'm happy to present to you this morning this couple, if I use that expression, Madam Ritu Tagore and Madam Sangeeta Rai. They are the best combination for this particular session. Thank you so much for accepting a request. Over to you.
Good morning to all. Thank you, sir, for introducing us as a couple. So I have been asked to give an overview of the Family Court Act 1984 and rules framed thereunder. Let me give brief introduction in this regard and about the concept of family courts. The amendments were made in CPC in 1976 to adopt a special procedure for solving familial disputes did not yield the desired result. So emphasis was laid on making efforts to reform as opposed to adversarial attitude while settling such disputes. Acting on the suggestions on 59th Law Commission report in 1974, the Family Court Act was enacted. It provided for establishment of family courts in different states and aimed at speedy and economical and less formalistic settlements. Now we come to the concept of family court. The concept of family court is not a novel concept. Such courts are functioning in some of the Western countries. So family dispute needs to be looked at as a social therapeutic problem and require guided solution. So family court judge should view family dispute not through a microscope but with a stethoscope. Judges in family courts are obliged to handle family matters with their heart. Now let's have a summary and or overview of the Family Court Act. The preamble of the Act gives insight into the main objective of this progressive legislation. It reads as such, an act to provide for establishment of family courts with a view to promote conciliation and secure quick settlements of disputes relating to marriage and family affairs and matters connected therewith. The Family Act is a procedural law. This act comprises of 6 chapters and 23 sections. Chapter 1 contains 2 sections. Government of Haryana and Punjab, after consultation with Punjab and Haryana High Court, framed the rules framed by the Haryana to regulate the working of the family courts are called the Haryana Family Courts Rules 2007, and by Punjab they are called as Punjab Family Courts Rule 2010, and rules framed by Punjab and Haryana High Court are called as Punjab and Haryana Family Court Rules 2005. The provisions of Order 32A CPC are also required to be looked into. Section 2 pertains to the definitions. This section contains 5 definitions. I'm skipping the definitions from clause A to D that are not relevant. Clause E says that all other words and expression used but not defined in the Act, defined in CPC, shall have meaning so assigned to them in the code. Family Court Acts does not define the expression family, but we can take help from Rule 6 of Order 32A CPC, which define family. Now we come to Chapter 2, which has 4 sections. Section 3 deals with the establishment of family courts in cities or towns and its local jurisdiction. Section 4 speaks about appointment of judges. Per this section, the state government with concurrence of High Court appoint one or more judges of family court. Subsection 2 speaks of each of the judges may exercise all or any of the powers conferred on the court by this act or any other law for time being enforced. Clause B speaks about appointment of judges as principal judge and other as additional principal judge. Clause C speaks about principal judge may from time to time distribute the business of the court amongst the judges as he may deem fit. And clause D speaks that in the absence of the principal judge, additional judge may exercise the power of the principal judge. Apart from other qualification as set out in the section 4, the other subsection 4 speaks that while selecting the judges for appointment as family court judges, every endeavor shall be made that he or should be committed to the need to protect and preserve the institution of marriage and welfare of the children and promote settlement of disputes by conciliation and counseling. So this is an important feature. This mindset would help in achieving the purpose for which the family courts have been set up, that is conciliation and settlement of disputes. Now, sometimes problem may arise that party may seek transfer of his case from one court to the other owing to certain reasons, namely some connected matter is pending in the other court, or the party may entertain some notion that he or she may not get fair trial in that court. In these circumstances, principal judge may transfer the case to the other court by taking the help of the provisions of subsection C of subclause C of subsection 2 of section 4. However, where there is there is one family court and transfer of the case is sought, on this aspect, the provisions of the Family Court Act and the rules framed thereunder are silent. To my mind, the district judge and the concerned family court judge may make a reference to the Honorable High Court. Per my opinion, learned district judge having general administrative control over his session division cannot transfer such family matter to other court of additional district judge by invoking the provisions of section 24 CPC, as learned session judge does not have the power to confer jurisdiction of a family judge by way of transfer of such case. The other course open for the agreed parties to approach the Honorable High Court for transfer of his case. Now we come to section 5, which deals with the association of social welfare agencies, institutions, persons professionally engaged in promoting the welfare of the family or working in the field of social welfare, or any person whose association with family court would help in enabling the family court to exercise its jurisdiction more effectively to discharge its function and purpose of the Act. Rule 10 of Haryana Family Court rules provide that judge shall maintain a panel of welfare agencies, institutions, especially in matter relating to children in case of guardianship matters, and call them as and when required. This rule also provides that court shall also maintain a panel of medical experts for assisting the court. So Rule 8 of Punjab and Family Courts Act is similar to this. Now we come to section 6, which speaks of the counselor, officer, and other employees of the family court. It says that state government, with consultation with High Court, shall determine the number and categories of the counselors to be provided to family court. Haryana Family Court Rule 6 states that there shall be center of counseling attached with every family court or group of family court. Rule 7 says that 3 counselors may be attached to every family court. The counselor will be appointed for the panel of the counselor prepared by judges of family court and approved by the High Court if so required. Rule 8 speaks about age and qualification of the counselor. It says that he should have experience in the field of social welfare, in the area of welfare of family or problem of women and children. Rule 9 pertains to the honorarium of the counselor. Rule 11 is again important. This says that counselor may visit periodically the residence of the parties, have interaction with the relatives, friends in order to reconcile the dispute and submit his report to the judge. Similar provisions are contained in Rule 5, 6, 7 of Punjab Family Courts rules. Now we look at the rules framed by our High Court, which are called as Family Court Rules 2005. Rule 13 speaks about association of counselor to the family court, and Rule 14 speaks that any stage of the proceedings, the court can take assistance of the relatives of the parties, social worker experts, bringing about a reconciliation or settlement between the parties. Now, Rule 15 speaks of the duties of the counselor. This says that court may direct the counselor to meet the parties or interview the relatives, acquaintances, or even the employer of the parties. Rule 16 speaks about the secrecy to be maintained by the counselor. This says the information gathered by the counselor, any note or a report prepared by him, or any statement made before him shall be treated as confidential. The counselor shall not be called upon to disclose such information, note, or report to any court except with the written consent of that party concerned. However, as and when the court directs, the counselor shall submit a report relating to home environment of the parties, their personal ties and relation with the children or the child, in order to assist the court in deciding the question of custody or guardianship or maintenance of the child or children. Now, Rule 17 says that family court may request the counselor to submit a report on any subject which may be necessary for adjudicating the matter before it. The councillor shall not be called upon to, Rule 18 says that the councillor shall not be called upon to give evidence in the family court. Now, Rule 19 speaks about the settlement to be made before the councillor. It says that if any settlement is arrived before the councillor, it shall be signed by the parties as well as by the councillor and can be put before the family court. If the family court is satisfied about the settlement being voluntary, just and fair, it may pass the decree thereof. Now, Rule 20 says that for deciding the interim application, the court may again direct the councillor to submit the interim report. Rule 22 speaks that the councillor has a right to supervise the custody of the children. If directed by the family court, he can pay a surprise visit to the house of the child where he resides and submit the report. Thereupon, the family court can pass an appropriate order. In Rajneesh versus Neha, the Honorable Supreme Court has observed that given the large and growing percentage of matrimonial litigation, it has become necessary that provisions of Section 5 and 6 of Family Court Act are given effect to by providing for appointing of the marriage counselor in every family court, which would help in the process of settlement. So Honorable Supreme Court of India in Santhini case also said that the role of the counselor in family court is basically to find out what is the area of incompatibility between the spouses. The counselor also assists the parties to resume free communication, and in custody matter also the counselor assists the child to accept the reality of the incompatibility between the parents. In both state of Haryana and Punjab, councillors have not been provided with most of the family courts. I would take this opportunity and request the Honorable High Court to take up the matter with concerned governments for appointment of the councillor as per rules with each family court, so to enable the courts to exercise the jurisdiction more effectively and speedily. Now, Chapter 3 has two sections. Section 7, it speaks about the jurisdiction of the family court. Section 8 is about exclusion of the jurisdiction of the other court with respect to the family matter. Section 7 is quite exhaustive in nature and gives jurisdiction to family courts to exercise in respect of the suits and proceedings as referred to in the explanation. Subsection 1 says that subject to the other provisions of the Act, family court shall have and exercise all the jurisdiction exercised by the district judge or subordinate civil court or even by the magistrate of first class under Chapter 9 of the Code of Civil Procedure relating to providing of maintenance to wife, children, etc. So the types of cases which are heard by the family court broadly can be categorized as per the explanation, namely dissolution or nullity of marriage, restitution of conjugal rights, determining the validity of marriage, matrimonial status of a person, suits or proceeding or injunctions or orders arising out of a marriage, custody, guardianship matters, or suit or proceedings for declaring legitimacy of a person, maintenance, property disputes between the parties to the marriage. So now we come to Chapter 4. It has two sections. Section 9 talks about duty of family court to make efforts for settlement. Subsection 1 of Section 9 says that in the first instance, family court in every suit shall make effort to convince the parties to settlement and consistent with the nature and circumstances of the case, and family court shall follow the rules so prescribed or such procedure as it may deem fit to arrive at such settlement. Now, subsection 9 speaks that the family court at any stage of the proceedings, if find there is a reasonable possibility of settlement between the parties, may adjourn the proceedings for such periods as it think fit. And according to me, Section 9 is the backbone of the Act, because absence of exhibition of due sensitivity of a judge of family court frustrate the very purpose for which the Act has been enacted and the courts have been established. It is often said that the best hour of justice is the hour of compromise, because in settlement, peace is purchased and both parties part as friends. There is always a chance of breakthrough. Therefore, family court judges should never stop making efforts for conciliation, We as judges of family court need to have a different approach, attitude while resolving the sensitive family matter. We need to play a role in sustaining the family. Peace and harmony in family is important for all-round development of humanity. In Hina Singh versus Satya Kumar case, it has been observed that main role of the court is to discover a solution instead of breaking family relations. It is also the social obligation of the judge to make earnest effort for reconciliation. In Shamima Faruqi case, it has been observed by Honorable Supreme Court of India that a family judge is expected to be sensitive to the issues, for he is dealing with extremely delicate and sensitive issues pertaining to marriage and issues ancillary thereto. He needs to be alert, wisely anxious, and conscious about dealing with the situation. We judges should not take our posting to family court as less charismatic or fascinating. I understand the task of being a family judge is emotionally draining, but smiles we put on families in a sincere conciliation efforts is worth the pain. Rather, we should take it as an opportunity given by Almighty for doing this noble duty of bringing peace to strife-ridden families. It should be taken as a service. I remind you, performing this role, you will be a better person. And I think the couple has become a better person. For myself, I can say that this role has made me a better person, a more refined human being, more cognizant, percipient to family needs, values, above all, a humble person. The sense of care, empathy, emotional psychology, art of being agreeable over disagreement has developed in me more than before. And please take this role as a mission. And I vouch that one smile of a family will keep nourishing your soul for times to come in your recollections. Now we come to section 10, which speaks about procedure generally. It speaks about use of CRPC and CPC. And the subsection 3 further provides that nothing in this section shall prevent the family court from laying down of its own procedure with a view to arriving at a settlement or truth of the facts alleged by the parties. This subsection is a dynamic clause. It empowers the family court to evolve its own procedure beside adopting the provisions of CPC and CRPC with a view to arrive at a settlement. So this brings informal character to the proceedings of a family court, another material feature of this act. Rule 25 of Punjab and Haryana family court rules provides that court shall be entitled to devise its own procedure in accordance with the rules of natural justice. Now, section 11 speaks about a camera proceeding. Section 12 speaks about assistance of medical and welfare experts. This I've already dealt with you and will not repeat the same. You can also look into Rule 10 of Haryana Family Courts Rule and Rule 8 of Punjab Family Courts Rule. Now we come to section 13. It speaks about right to legal representation. Section provides that notwithstanding anything contained in any law, no party to suit or proceeding before a family court shall be entitled as of right to be represented by a legal practitioner, provided that a family court consider it necessary in the interest of justice to seek the assistance of legal expert as amicus curiae. Rule 12 of Haryana Family Courts Rule provides that a judge shall maintain a panel of legal experts as amicus curiae, and at least panel of 5 amicus curiae shall be maintained by each family court. And Rule 13 provides a party is entitled to take legal advice at any stage of the proceedings before the court and is also entitled to have a free legal aid if the party is indigent. Rule 14 provides maintaining a panel of lawyers willing to render free legal aid. Rule 9 of Punjab Family Court Acts contains the similar provisions. Often a family court judge is confronted with the question whether a party has a legal right to be represented by his counsel or through amicus curiae. The main clause of the section of the Act prohibits a party from engaging a counsel as a right, but that does not take away the powers of the court to permit a party to seek assistance of a lawyer judicial discretion is required to be exercised by the family court, which should be guided by reasons and should not be vague, arbitrary, or fanciful. I'm quoting some of the decisions for our guidance. Shrimati Mangla Surya Deva versus Dr. Srinivasa Reddy. In this case, Honorable Karnataka High Court has held that a party even to matrimonial proceedings cannot be denied right to be represented by authorized agent or power of attorney. In Krishna Murari versus State of Jharkhand, Honorable Jharkhand High Court observed that Section 13 of the Act does not completely forbid engagement and appearance of advocates in family courts on behalf of the parties. It further observed that the trained legal practitioner, well versed with the complexities of law and fully conversant with procedure of court, save precious time of the court and render proper assistance, whereas parties personally lean to the court proceeding. It also observed that a power to grant permission also includes power to revoke the permission. If any stage of the proceeding, the court finds that presence of lawyer is not helping the party, it may revoke the permission. Now, question often arises that difficulties arise when the parties are not appearing in person and advocates are filing memo of appearance. I think this query stand answered by way of the observation quoted by me. Yet, according to my mind, learned judge may direct the counsel to cause the appearance of the parties in person or may impose a token cost for violation of the directions of the court given to the advocate for causing the appearance of the party. If after one or two reasonable opportunity party is not appearing and no permission has been taken from the court by the party for being represented through counsel, the court may proceed as per the provisions of CPC, CRPC treating non-appearance of the party. Now, VC rules have also been framed. The party can be asked to appear before the court through VC. And I'm of the view that association of the councillors with the every court would reduce the representation of the lawyer for the parties. Now we come to section 14, which speaks about application of Indian Evidence Act. It provides that family court may receive an evidence in shape of report, statement, documents, in which in the opinion of the court would assist it to deal with the matter effectively, whether bothering about whether such evidence is relevant or admissible under Indian Evidence Act. Section 15 empowers the court to record oral evidence of the witness in the shape of memorandum. And section 6 talks about taking the evidence of formal witness on evidence. The above three sections would show that family courts have been constituted to provide ready justice to the party to family dispute, and court should not stand on unnecessary technicalities. The court must invoke the powers that are available under section 9, 10, 14 and relevant rules of procedure of family courts. In Roshanlal versus State of Haryana, it was held that provisions of section 15 and 16 of Family Courts Act do not render evidence taken on affidavit as illegal. In Pramod E.K. versus Lona, it was observed that by the Honorable Kerala High Court that section 14 of Family Courts Act aims at mitigating the rigor of sophisticated rules of relevancy and admissibility of the evidence. The family courts are bound to adhere to fundamental rules of evidence based on logic, fairness and expediency, and also principle of natural justice. In the Pali Santokh Lakhande case, the Honorable Bombay High Court observed that in matrimonial cases, the family court is expected to adopt standard as how a prudent person would gauge the realities of life, and approach of a family court is required to be realistic and rational to the facts in hand rather than technical and narrow. Now we come to section 17. It speaks about the judgment of a family court. It says that it must contain a concise statement of a case, point of determination, decision thereon, and reasons for the said decision. Section 18 speaks about the executions of decree and orders. For that, we can take help from the provisions of CPC, CRPC. Accordingly, So we need to keep in mind the section 125 subclause 3, 128, 421 CRPC and provisions of CPC with respect to civil imprisonment, attachment of property as provided under section 51, 55, 58, 60 Red Order 21. And please go to through the observation made in Rajneesh versus Neha in this regard. Execution are difficult to satisfy owing to various factors, and when it comes to the family court matters, it becomes all the more tricky and delicate when a decree for conjugal right is asked to be executed. For that, we need to go through the provisions of Order 21, Rule 32 and 33. The combined reading of these orders shows that the decree under Section 9 can be enforced by applying the sanctions contained therein, that is by attachment of the property of the JD. The other course open for either of the party to the marriage is to present a petition for divorce under Section 13(1)(a) capital HMA after 1 year of non-compliance of decree of conjugal rights, but under no circumstance the court can force the erring spouse to consummate the marriage. In Lakhvinder Kaur versus Gurmail Singh, it was observed that there can only be symbolic execution of decree of restitution of conjugal rights. There is no provision under which the physical custody of spouse can be made over to spouse who has obtained the decree of restitution of conjugal right. Maya Devi versus Kailash Chandra, in this, it has been observed that decree of restitution of conjugal rights can be enforced by attachment of property or financial sanction, and if the party still does not comply with the decree of the court, may punish him or her for contempt of the court, but under no circumstance court can enforce the erring spouse to consummate the marriage. Either party can file execution application for recording satisfaction of the decree. Once a decree of restitution of conjugal rights is passed and one party has departed away from the decree, then the other spouse can have liberty to get the decree satisfied in its proper way. In Bimla Devi's versus Singh Raj case, it was observed that relief under section 13(1) capital A cannot be made non-existent by applying the provisions of section 23 subsection 1 and clause A HMA merely because he or she has failed to comply with such decree. Now we come to chapter 5. It has one section, the section 19, which speaks about appeal, and section 6, chapter 6 has 4 sections. Section 20 is about states that act to have overriding effect. So it's being a special act and thereby will have precedence over the other acts. Now section 21, 22 and 23 speaks about powers of the High Court to make rules, and central government to make rules, and state governments to make rules to carry out the purposes of the Act. So this, by this short topic, I have given you the overview of this or summary of the Family Court Act 1984. Thank you very much. Now over to my friend and colleague, Sangeeta Rai.
Thank you, ma'am. Thank you so much. Good morning, everyone. Today I shall be discussing 2 topics. Firstly, the jurisdiction of the family court with regard to property disputes, and secondly, with regard to DNA test. Regarding the jurisdiction of the family court, as Madam has rightly mentioned here, Section 7 of the Family Court Act gives exclusive jurisdiction to the family court to deal with matters which are elucidated in explanation to Section 7. The Act specifically sets out the proceedings which are cognizable by the family court, and therefore no civil court or magistrate court has jurisdiction to try any matters which are set out in the explanation if a family court is established in the area. I may also mention here that the family court exercises the powers of a district court as well as of a subordinate civil court as per the nature of the dispute. Now coming to the explanation, Since I'm only discussing jurisdiction regarding property disputes, I will only discuss subclause C, D, and E, which are the relevant subclauses. Subclause C says a suit or proceeding between the parties to a marriage with respect to the property of the parties or either of them. Subclause D says suit or proceeding for an order or injunction in circumstances arising out of a marital relationship. Further, subclause G says a suit or proceeding in relation to the guardianship of the person or the custody of or access to any minor. Therefore, unless the suit falls within one of the aforementioned categories, that is categories A to G, the family court gets no jurisdiction. As Madam has just mentioned, Section 8 of the Act, it excludes the jurisdiction of other courts where the matter is covered by the family court. And Section 20 has an overriding effect on other laws. Now I shall refer to some of the precedents regarding the jurisdiction on property. In Devki Anantharajanam, the Honorable Kerala High Court, in a suit for partition in which not only the husband and wife, but their children were also parties, held that it did not fall within the exclusive jurisdiction of the family court, and the decree in the suit passed by the civil court was not void. Then in Pre-Sihari versus Sukunda, the Honorable Andhra Pradesh High Court has held that family court has no jurisdiction to entertain suit where dispute is between brothers, sisters, mother, father concerning property. The family court was directed to return the plaint for presentation before proper court. In another judgment, Joseph versus Mariam Thomas, a claim of a stranger over a property over which the wife has a charge for her maintenance was not required to be adjudicated in the family court. A landmark judgment on this subject is Genu versus Jalalabai, in which the Honorable Karnataka High Court has reiterated the aforesaid principles, and it has held that if persons other than the parties to the marriage have an interest in the dispute, the family court has no jurisdiction to adjudicate the dispute. In other words, the parties to the marriage cannot claim right in property in which third parties also have an interest before the family court. Further, a contrary view has been laid down by the Honorable Karnataka High Court in Shivamma versus Sangappa. In this case, defendant number 1 was the wife of the plaintiff as well as of defendant number 2, and defendants 6 to 9 were the children of the plaintiff and defendant number 1. The tenants of the suit property were also parties to the suit. The plaintiff and defendant number 1 had purchased the property jointly and were joint owners of the same, and the plaintiff had made a claim for his share in the suit property, which was refused by defendant number 1. The Honorable High Court has observed the trial court, the defendant had contended that the trial court had no jurisdiction to try the suit on the grounds that the suit was not between husband and wife, but the interests of the children was also to be looked into but the trial court did not accept this contention. The Honorable High Court held that the plaintiff and defendant number 1 are husband and wife, and the plaintiff husband has filed the suit for partition, seeking half share in the suit scheduled property. And as such, the finding recording by the trial court does not call for any interference by this court. In some cases, there is overlapping between clauses 7(1) in between subclauses C and D of the explanation. In Blessy Varghese, the children of the deceased mother raised claim against the father seeking declaration of title over the scheduled property and also for realization of amounts towards marriage expenses. It was held that though the case was not covered by clause C, but it was perfectly within the scope of clause D. It was observed that if the cause of action agitated is based on the rights and obligations of the parties which are arising out of a matrimonial relationship, it would clearly fall within clause D to section 7(1) of the Family Court Act. A similar view was expressed in Suprabha versus Sivaramman, in which the Honorable Kerala High Court has held that where either husband or wife is not alive and suit is filed against the parents of either of them, it cannot be said that the suit or proceeding between that it is a suit or proceeding between the parties to the marriage. Having said that, the Honorable High Court further held that though the case did not fall in clause C, but it was covered by clause D. Now we have another situation in which a suit is filed by a widow claiming a right in the share of the husband in the business with third party. Here the Honorable Bombay High Court has held that in no case clause D of explanation to section 7 of the Family Court Act can be interpreted in such a wider way to hold that whenever any person is claiming right in the share of the husband in the business with third party, such dispute will lie in the jurisdiction of the Family Court. A contrary view was given in Shiny versus George, where a wife sues her husband for recovery of her property, and when in such a suit the wife is obliged to add a close relative of the husband or even a stranger on the allegation that the husband made over the property to that close relative or stranger, it was held that the jurisdiction of the Family Court will not stand ousted to deal with the claim. Now, in Vasumati versus Valsang in 2011, where a petitioner had sought a succession certificate, the High Court had held that the absence of such a power having been conferred on the Family Court, Civil Court was not right in transferring the proceedings to the Family Court. The next issue on this subject is properties of divorced parties. The landmark judgment is K.A. Abdul Jalil versus T.A. Sahida. In this, the Honorable Apex Court held that if the words "a suit of proceeding between the parties to a marriage" are interpreted as parties to a subsisting marriage, then it would lead to miscarriage of justice and would frustrate the object wherefore the family courts were set up. In another suit, which was filed by a father-in-law seeking an injunction, it was held to be not maintainable, and it was held in Rakhi versus Jayendra by the Honorable Bombay High Court that the suit for an injunction restraining the daughter-in-law from entering the house which he claimed to be belonging to him absolutely was not transferable to the family court. Whereas suit for injunction was filed by father-in-law against daughter-in-law for enforcing proprietary rights. This was also held to be not maintainable before the family court by the Honorable Kerala High Court in Mini and others versus Sivaraman and others 2021. This is the latest judgment on this point. It was further held that enforcement of proprietary rights of the plaintiff over any person is not a circumstance arising out of a marital relationship, merely because the person sought to be proceeded against happens to be the daughter-in-law and grandchildren. The High Court further held that it is not the nomenclature of the relationship which will determine whether a matter falls under section 7(1) explanation D or not. Nomenclature of the relationship will be relevant for matters coming under section 7(1) explanation C, while what is relevant for section 7(1) explanation D is nature of cause of case and cause of action. Again, a mother-in-law filed a suit against the daughter-in-law seeking her ejectment. It was held in Manita Khurana's case that the suit was not maintainable before the Family Court Act. It was held that claim of third party to a marriage, even if she be the mother of one of the spouses, cannot be adjudicated before the Family Court. In Krishnamurthy versus Somaiya Krishnan, the Honorable Kerala High Court has defined the expression circumstances arising out of a marital relationship, and it has held that it means not only those occurrences which transpired during the marital life, but should also include such circumstances which led to the marriage, which developed thereafter, which took place during marital life, which resulted in breaking down of the marriage, and also those which closely followed as a consequence of all these. This was again reiterated by the Kerala High Court in Levy Isaac versus Lena judgment in 2005. In a recent judgment, Vivek Singh versus Yogendra Singh Thakur, the Honorable Chhattisgarh High Court has held that where a suit was filed by the father of the deceased wife before the family court, it was not maintainable, as the suit can be preferred only by parties to a marriage and not by any other person. So as you can see, there are very conflicting views, but the latest judgment on this point is of Vivek Singh versus Yogendra Singh. Now there is another issue where the husband has filed, the wife had filed an application for deletion of second wife's name for service record of husband. The plea of the husband was that nomination and service record is service dispute within the purview of administrative law, and family court does not have jurisdiction. But the Honorable High Court held that since nomination and subsequent deletion of name of wife was circumstance arising out of marital relationship, family court had jurisdiction to entertain the prayer of the wife. Another judgment I would like to refer to is Janaki Amma versus Renuka, 2016 Kerala High Court. In this, it was held that prime consideration should be as to whether the cause of the list has got any bearing with marital relationship. An objective assessment should be made as to whether the cause has got any stem from these circumstances arising out of the marital relationship. In other words, whether the cause should have been existed but for the marital relationship shall be the basis of the assessment. If the answer is in the positive, definitely the list can be categorized as one coming within the scope of explanation D. So whereas explanation C, as you must have noticed, has a limited scope, the scope widens in explanation D because of the very nature of the disputes covered therein. In Nuti versus Vashishta, the Honorable Supreme Court has held that in this matter, a civil revision petition was filed by the petitioner not to divulge the contents of the proceedings pending in the family court or any material concerning the disputes between them without obtaining the specific leave of the court to any unauthorized third party, including the media. The Honorable High Court has held that jurisdiction conferred on the family court under Section 7 has to be liberally construed, and parties to a proceeding before the family court, like the petitioner, cannot be compelled to approach the ordinary civil court for any relief, interim or final, in connection with the matrimonial dispute he has with the respondent. There is also the issue of jurisdiction regarding foreign nationals. The judgment on this point is Jyoti Lakhtakia versus Vineet Mehra, in which it has been held by the Honorable Apex Court that it is only the jurisdiction which is exercisable by the district court or any subordinate court which gets vested in the family court qua dispute between the parties to the marriage. If the district court or courts subordinate to it do not have territorial jurisdiction, the family court would not get jurisdiction to deal with such a suit. There are also contrary views regarding the jurisdiction of the family court with regard to suits of the property of the minor. Whereas in Tarun Chandra Deka, the Honorable Guwahati High Court has held that the word person appearing in clause G must be read to refer to a minor as a person and not necessarily to the person of a minor. This apart, the expression in relation to is, as discussed above, an expression of very wide meaning and must be construed to mean all sorts of proceedings which relate to the guardianship of a minor as a person. Logically extended, this would mean guardianship of not only the person of a minor, but also the property of the minor. However, contrary view has been expressed in a very recent 2021 judgment by the Honorable Kerala High Court in K.S. Narayana, in which it has been held that district courts are empowered only to appoint guardian of minor's property and minor's person, and for minor's property it is the district courts are empowered to appoint a guardian for a minor's property, and for minor's person it is the family court that is empowered. Finally, I would like to refer to Neelkant Jaiswal's judgment, in which the respondent in a suit for restitution of conjugal rights had filed an application under Section 27 of the Hindu Marriage Act for claiming the return of the Istridhan. The family court directed the return of the Istridhan, and it was held that the relief regarding the suit filed by the respondent claiming return of Istridhan was maintainable under clause C of the explanation to subsection 1 of section 7. Now I will be coming to the next topic, which is DNA test. DNA is unique to an individual, barring twins, and can be used to identify a person's identity, trace familiar linkages, or even reveal sensitive health information. Section 112 of the Evidence Act very clearly provides that the fact that any person was born during the continuance of a valid marriage between his mother and any man, or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man, unless it can be shown that the parties to the marriage had no access to each other or at any time when he could have been begotten. From a plain reading of this section, it is evident that the provision makes the legitimacy of the child to be a conclusive proof if the conditions stated therein are satisfied. Earlier, there was a controversy as to what is the true import of the word access in section 112 of the Act. Some high courts held that access means actual sexual intercourse between the spouses. However, the controversy came to rest in 1934 when the Privy Council held in Karappa Sirevai's case that access connotes only existence of opportunity of matrimonial intercourse, and in case such an opportunity was shown to have existed during the subsistence of the valid marriage, the provision by a fiction of law accepted the same as conclusive proof of the fact that the child born during subsistence of the valid marriage was a legitimate child. This said legal principle gained approval of the Honorable Apex Court when a 3-judge bench in Chilukuri Venkateshwarlu held that the law had been correctly laid down by the Privy Council. Again, in Gautam Kundu's judgment in 1993, Honorable Apex Court has held that the section requires the party disputing the paternity to prove non-access in order to dispel the presumption access and non-access. In Gautam Kundu's case, it was also held that the courts in India cannot order blood test as a matter of course wherever applications are made for such prayers in order to have roving inquiry. The prayer for blood test cannot be entertained. There must be a strong prima facie case in that the husband must establish non-access in order to dispel the presumption arising under Section 112 of the Evidence Act. The court must carefully examine as to what would be the consequence of ordering blood test, whether it will have the effect of branding a child as a bastard and the mother as an unchaste woman, and no one can be compelled to give sample of blood for analysis. Gautam Kundu's case was clarified by Honorable Apex Court in Sharda versus Dharampal, and it was held that Gautam Kundu is not an authority for the proposition that in no circumstances the court can direct the blood test be conducted. Having regard to future of the child, if it is required, but the DNA test should be ordered, but if the Honorable Apex Court sounded a note of caution regarding mechanical passing of such orders. Therefore, there is no conflict in the aforesaid two judgments. Another landmark judgment on this subject is Banarsi Das versus Tiku Datta, 2005 Supreme Court. The core question involved in the appeal was whether direction for DNA test can be given in proceedings for issuance of succession certificate. The trial court allowed the application, but the Honorable High Court found it was not a fit case where such a direction could be given. The Honorable High Court observed that Section 112 of the Evidence Act requires the party disputing the parentage not to prove non-access in order to dispel presumption of fact of the Evidence Act. It also held this presumption can only be displaced by a strong preponderance of evidence and not by a mere balance of probabilities. In Duktar Jahan's case, again it was held by the Honorable Apex Court in the year 1987 that it is for the parties to place evidence in support of their respective claims and establish their stands. DNA test is not to be directed as a matter of routine and only in deserving cases. Now, what is the standard of proof required for presumption under Section 112? In Kamti Devi versus Poshi Ram, the Honorable Supreme Court has held. In this case, the husband had filed a civil suit for a decree declaring that he was not the father of the child, as he had no access to the appellant during the period when the child would have been begotten. The trial court relied on the conclusive presumption mentioned in Section 112 of the Act and held that the husband failed to prove that he had no access to his wife during the relevant period, and the suit was dismissed. The appeal was allowed and the Honorable High Court refused to interfere. The Honorable Supreme Court also dismissed the appeal. It was held. Normally, the rule of evidence in other instances is that burden is on the party who asserts the positive, but in this instance, the burden is cast on the party who pleads the negative. The reason is the legislative concern against illegitimizing a child. It is a sublime public policy that children should not suffer social disability on account of laches or lapses of their parents. I will also like to refer here to judgment cited Shamlal versus Sanjeev Kumar, 2009 Supreme Court, in which it was held that the presumption under 112 cannot be displaced by a mere balance of probabilities or any circumstances creating doubt. Even the evidence of adultery by wife, which though amounts to very strong evidence by itself, is not quite sufficient to repel this presumption and will not justify finding of illegitimacy if husband had access. Again, in Bharata Mata versus R. Vijaya, the Honorable Apex Court has held that presumption under Section 112 can be displaced only by a strong preponderance of evidence and not merely by a balance of probabilities, as the law has to lean in favor of innocent child from being bastardized. Now I would like to refer to judgment of our own High Court, Sube Singh versus Shanti Devi, 2015. The dispute in the suit was with respect to rights and shares in the suit property. The suit instituted by the petitioner was for declaration of ownership and possession. It was pleaded that the contesting parties were stepbrothers and sisters. Resisting the suit, the defendant claimed that there was no commonality of blood between them. When plea of denial was entered by the defendant in the suit, plaintiff number 1 moved an application praying that DNA profile test be conducted between the parties for removal of doubts as to maternity. The trial judge accepted the prayer for conducting of DNA profile tests and took recourse to enforce his order by granting police help and use of force to carry out the DNA profiling test. The order was challenged before the Honorable High Court, which observed, in the diametrically opposite stands of the parties, I cannot reasonably fathom as to how the dispute can be readily resolved by oral and documentary evidence alone. The parties being at loggerheads and limited by court evidence system, and therefore the eminent need test applied by the Supreme Court in Bhabani in venturing to arriving at the truth by the result of the genuine DNA profile test should be followed here in this case, which will erase any possible undue advantage either party may have without it. So the Honorable High Court has upheld the order and said that force could be used for enforcing the order of the court. It also held that otherwise it would make a mockery of the order of the court. But contrary view has been laid down by the Honorable Apex Court in Rambali Mishra's case, in which it has held that nobody can be compelled for DNA test and the same cannot dilute the presumption to be drawn under Section 112 of the Evidence Act. In Kamlesh Yadav's case also, similar view was expressed that a party cannot be forced to undergo a DNA test and the wife is at liberty to comply with or disregard the order of the High Court if she order of a DNA test, and if she accepts the direction, DNA test would conclusively determine the veracity of accusation leveled against her. However, if she declines, then an adverse inference can at best be drawn against her. The next issue is regarding the stage when to order a DNA test. In Dagu Gopal, the Andhra Pradesh High Court in 2013 has held that in a suit where seeking a declaration was filed by the father of the plaintiff, suit seeking a declaration that the defendant was the father of the plaintiff due to long cohabitation as man and wife, but the first defendant claimed no acquaintance with the plaintiff or his mother and asserted that both of them were strangers to them. The said application was allowed by the court, and challenging the correctness of the order, a revision was filed in the High Court, which allowed the revision and remitted the interlocutory application for considering afresh at a later point of time, by holding that the stage of the suit was premature. The court held that if strong prima facie material about the marriage between the parties and that the defendant had gained access to the second defendant had been produced before it, only then the application for DNA should be allowed, and the stage was premature when the same was allowed by the court. The next issue is what is to be done when there is a conflict between conclusive proof under Section 112 and DNA report. In a landmark judgment, Nandlal Vasudeo Badbeg, the Honorable Supreme Court held that in this case, I would like to make a brief mention of the facts. The wife had pleaded that the husband had access to her, and in fact, the child was born in the said wedlock. But the husband had specifically pleaded that after his wife left the matrimonial home, she did not return, and thereafter he had no access to her. The wife has admitted that she had left the matrimonial home, but again joined her husband. None of the courts below had given any finding regarding the plea of the husband that he had no access to his wife at the time when the child could have been begotten, and DNA test was ordered and conducted. The Honorable Apex Court held that, as stated, DNA test is an accurate test, and on that basis, it is clear that the appellant was not the biological father of the girl child. However, at the same time, the condition precedent for invocation of Section 112 of the Evidence Act has been established, and no finding with regard to plea of the husband that he had no access to his wife at the time when the child could have been begotten has been recorded. Admittedly, the child had been born during continuance of valid marriage. Therefore, provision of 112 of the Evidence Act conclusively proves that respondent number 2 is the daughter of the appellant. At the same time, DNA test reports based on scientific analysis in no uncertain terms suggest that the appellant is not the biological father. In such circumstances, which would give way to the other is a complex question posed before her. In our opinion, when there is a conflict between a conclusive proof envisaged under law and a proof based on scientific advancement accepted by the world community to be correct, the latter must prevail over the former. A test of proportionality was again reiterated in a very recent and landmark judgment, Ashok Kumar versus Raj Gupta. in which it was held that whether a person can be compelled to provide a sample for DNA in such matters can be answered considering the test of proportionality laid down in the unanimous decision of this court in Justice K.S. Puttaswamy versus Union of India, wherein the right to privacy has been declared a constitutionally protected right in India. The court should therefore examine the proportionality of the legitimate aims being pursued, that is, whether the same is not arbitrary or discriminatory, whether they may have an adverse impact on the person, and that they justify the encroachment upon the privacy and personal autonomy of the person being subjected to DNA test. When the plaintiff is unwilling to subject himself to the DNA test, forcing him to undergo one would impinge on his personal liberty and his right to privacy. So in the precedents, there are two tests which have been laid out. One is that of imminent need, that there should be an imminent need for a DNA test. And second is right of proportionality, that the court has to see take both factors into and create a proportion, whether the DNA test is to be given or whether is to be ordered, keeping in view the right of privacy of the person against whom the order is being passed. There is another issue that when a child himself approaches the court for DNA test, this question was before the Honorable Supreme Court in the famous N.D. Tiwari case, in which it was held that there would be no question of protective jurisdiction of the court since the declaration sought is on his or her behalf about the true paternity as opposed to the legitimacy ordained by law. The issue of applicability of Section 112 has to be seen from different trajectory than in the decided cases, where it can be established that the husband is not the father of the child through scientific tests conducted upon them voluntarily. The presumption of Section 112 can stand rebutted prima facie. If the interests of the child are best subserved by establishing paternity of someone who is not the husband or his mother, the court should not shut the consideration altogether. The protective cocoon of legitimacy in such cases should not entomb the child's aspiration to learn the truth of his or her paternity. The court is of the opinion that legitimacy and paternity are both valid interests of the child that may be accorded recognition under Indian law without prejudice to each other. While legitimacy may be established by a legal presumption, paternity has to be established by science and other reliable evidence. In this specific matter, the plaintiff had sought a declaration as to his paternity. Any such declaration will have no bearing on his legitimacy, which as such will continue to be governed by the conclusive presumption of Section 112. The question of timing was again discussed by the Apex Court in Ashok Kumar's judgment, which I have referred above, in which it has been held that the nature of evidence, nature of further evidence to be adduced by the plaintiff by providing DNA sample need not be ordered by the court at the instance of the other side. In such kind of litigation, when the interest will have to be balanced and test of imminent need is not satisfied, in our considered opinion, the protection of the right of privacy of the plaintiff should get precedence. It also held that the plaintiff had adduced documentary evidence and was disinclined to produce further evidence. Therefore, he was aware of the adverse consequences of his refusal, but in standing firm in refusing to undergo the DNA test, his suit eventually will be decided on the nature and quality of the evidence adduced. I will just make a reference. This may be causing a little confusion here. Appellant Ashok Kumar had filed a civil suit seeking a declaration of ownership of property left by his parents. He had arrayed three daughters of his parents, the Lokchand Gupta and Sona Devi. In the written statement, the defendants denied that the plaintiff was the son of their parents. And once the plaintiff had concluded his evidence, the sisters moved an application for DNA test. The application was opposed by the plaintiff, saying that it is an abuse of process of law. So in this, the application was dismissed by the trial court. The High Court, the defendants moved the High Court in a revision petition that there the High Court observed the DNA test was a double-edged weapon, and is a vital test to determine the relation of party of the plaintiff who is claiming to be the son of Trilokchand and Sona Devi. So it should not shy away from the DNA test. And in the appeal, the Honorable Apex Court has observed that since the plaintiff had already adduced his documentary evidence and he was disinclined to go for a DNA test and was also conscious of the adverse consequences of his refusal, but was standing firm in refusing to undergo the DNA test, and his suit would eventually be decided in nature and quality of the evidence adduced. Therefore, he could not be forced to go in for a DNA test. So I would just wrap up by saying that the basic principle is that the DNA test is not to be ordered casually, and the court has to see that there is an imminent need for ordering. The court has to see that the proportionality between the DNA test and the right of privacy has to weigh both these factors before ordering a DNA test. As per the latest judgment, a person cannot be forced to undergo a DNA test. And before ordering the DNA test, court is also to see that evidence making out a prima facie case on the basis of preponderance of evidence has been established by the party before such a DNA test can be ordered. Thank you so much. Yeah, sorry, there was another question regarding preservation of record. In that, I would just say one line that if an application is moved for preservation of call records, the court should definitely allow the application, because there is a timeline for which the call records are preserved by the companies, and and if the same is not ordered to be preserved, the record is likely to be lost, and which would cause great prejudice to the party who would like to rely upon it at some later stage of its case. Thank you so much.
Suji, good morning.
मेरा कैमरा बंद है? ओहो, ऑफ कर दो, ऑफ कर दो। कैमरा ऑफ है, माइक ऑन। ओके। बट आई Yes, we'll start.
Permit me to do that. Good morning. We are in now for the second session of the day. This particular session is dedicated to the role of the judges in divorce proceedings. We have this morning with us for the opening remarks, Honorable Justice Ritu Bari. What a blend of the bar and the bench. 23 years at the bar, 12 years on the bench. Rich experience, and also chairing the committee on family court matters of the Honorable High Court. Speaking personally, Justice Ritu Bari, I have enjoyed my association. Right from her college, university days to the bar, and I had the privilege of arguing cases before her. It has been an enriching experience of this association. What a good human being and what contribution she has made. We are looking forward to your opening remarks in this particular session. Over to Justice Ritu Bari.
Good morning to everybody, and thank you very well, Dr. Balram Gupta, for speaking so well for me. And well, one has learned a lot in these 12 years, and I'm lucky that I have an occasion to interact and to share my views with all the judicial officers who are dealing with the family courts. And it is something which is part of our culture. We see everybody around in families, and we see the importance of a family in our entire life. And family in our society means the foundation of growth of every human being. So emotions are part of growth. And in this backdrop, we can all interact and exchange our views. And at the outset, I don't want to give a very long lecture or an introduction, whatever, but I can share only one thing with all of you is that the High Court has already decided, and it is in the process of amending the family court rules of Haryana, Punjab, UT, and High Court, and we are proposing to have counselors who will assist the family law courts, 3 counselors who will assist the family law courts in these matrimonial disputes, so that whenever a case comes, the family court can take assistance of these counselors, and these counselors will have meeting with the families. They can even go to their house, see the environment of the child, and then give their advice and make a report. So the time limit fixed as per the amendment, which is being to be is on the process, is about 1.5 months. So this, because we have been getting requests from the family court judges also to have counselors. So this process that is why I'm only going to say about this amendment now, because that will hopefully bring out a change in the decision-making powers also, and even in giving consultation to the families or the educated parents about the process in which they should lead a divorce proceeding if they can't stay together, and how to look after the needs of the child, which is the most important thing in this region. And I'm sure you must be aware, all of you, that in the mediation, the 75% or 70% cases are matrimonial disputes. So that's a big cult of litigation, which the mediations also have to face. But since the rules are now being in the process of being amended in all the 3 states, in both the states, UT as well as the High Court, so these counselors will be appointed, will have a background of social science, psychology, clinical psychiatry, and they will be working under the family courts, monitored by the family court officers, and then give a report. Even their fee structure has been revised so that we attract good talent at every district level to assist the courts. And my experience is that pre-litigation state cases which are registered in the police stations, they should also be referred for mediations for counseling, because that is the stage when they require maximum counseling and advice to be given. So these are the amendments which are in the process now, and hopefully it will be carried out. So that will make a substantial change in the way to deal with matrimonial disputes. Of course, the law is very settled, but sometimes the advice is required at the initial stage when the parties separate. By the time they come to High Court and Supreme Court, many years are lost, and they can't go back, and they can't even repair their mistakes which they made in the initial years. So this is what we are proposing for all the 3 states, and this has been finalized, almost finalized. It will be sent to the government eventually. So apart from that, my personal experience in one case is that there was a couple who had come up in appeal, who after 13B divorce had patched up, young couple, and they had 2 children. So incidentally, that day there was another couple who had come for who was seeking, they were in appeal of a divorce had been granted. It is my experience that I sent that couple to sit with, both the couples were sent together to sit for an hour and a half. And the second couple came back and said, we'll also patch up. So sometimes the judges and the lawyers and the mediators can't give so advice where the realistic advice is given. So that couple who was there had got divorced. They decided to patch up for their children. So realities sometimes are required to be told to the litigants. That is why if counselors are there, they can give the realities of a child who's suffering. Because my experience, what I've interacted with the psychologist is the children start stammering, they lose their memories, they can't speak well. When they go through the stress between the parents. So that is where at least we have to be a little bit more sensitive. And of course, otherwise, on the other side, giving there is one issue also that if a 13B divorce is to be given and the parties is not in India, can it be given through virtual? There was a judgment which we had passed, which was upheld by the Supreme Court, that even registration of marriage can be done virtually. But the general power of attorney has to be sent to one of the parent. So we have to crease out the technical hitches so that the families who have decided to part ways, even virtually their statements can be recorded if power of attorney is sent to one of the parents. So these are the small things which require improvements, but this amendment will come. I'm sure it will make a difference in the family law courts in the times to come. And now, Dr. Balram Gupta, you can start off with your conference.
Thank you so much.
Yes.
Showing the path forward has been the object of this morning session as such. Your observations would go a long way in guiding the judges and the resource persons to deal with those particular issues as such. This session is being shared by 2 resource persons, one our own from the Academy, Madhu Khanalali, and Mr. Anil Morodra. I'm so happy to introduce both of them. Madhu, with a good academic base, joined as a judge, long judicial experience. In the year 2012, she came to the Superior Judicial Service, and last year she came to the Academy, being part of the faculty as such. You know, the faculty of Chandigarh Judicial Academy, we are proud of them. They contribute and contribute immensely in this particular process. This workshop, she has worked hard, and I'm sure that the contribution that she's going to make in this particular session, as also tomorrow as well, would be a guiding factor for the family court judges for the future. to deal with various issues as such. I'm equally so happy to introduce Mr. Anil Morodra, who of course doesn't need any introduction, particularly in the domain of the family matters or family law as such. I've known him since 1980 as a student, as a co-runner in the profession, and as an author. He argues cases, writes, authors, books, and this combination, that his books are based upon the cases that he has argued in the other cases as such, enriches the legal literature, particularly in the domain of private law. I've been associated with his books in one form or the other. And therefore, the experience that he brings in would go a long way in generalizing this particular workshop relating to the family court matters. Thank you so much, Anil, for sparing your time to be with us this morning. May I now request Madhu to carry forward the session. Madhu.
Thank you, Dr. Balram Gupta. Good morning, everyone. It is a privilege to address very learned and distinguished audience. But due to constraint of time, the subject of my presentation is limited only to certain aspects of divorce under the Hindu and Muslim law and the ancillary provisions. If marriages are made in heaven, as Tennyson said in Eleanor's Field, why make a matrimonial home hell is a big question. The provisions relating to divorce categorize situations in which a decree for divorce can be sought for, but merely because such a course is available to be adopted should not normally provide incentive to persons to seek divorce unless the marriage has irretrievably broken. Effort should be to bring about conciliation, to bridge the communication gap which led to such undesirable proceedings. People rushing to courts for breaking up of marriage should come as a last resort, and unless it has an inevitable results, courts should try to bring about conciliation. The emphasis should be on saving the marriage and not breaking it. This is more important, as Lordship has also pointed out, in cases where the children bear the brunt of dissolution of marriage. The worst affected victims of divorce are probably the children. The most traumatizing situation for a child is perhaps seeing one's parents getting separated. Being the constant witness to fights and emotional turmoil among his or her parents is certainly an unfortunate circumstance for a child. As for a child, both his parents are dear to him or her. Being away from one of them can hamper his emotional state of mind severely. It has been held in case titled Rosie Jacob versus Jacob A. Chakramakal, AIR 1973, Supreme Court 2090, that the children are not mere chattels, nor are they mere playthings for their parents. In these circumstances, it has to be kept in mind that the child is both a hope and a promise for mankind. The greatest gift we can give our children are the roots of responsibility and the wings of independence. Often it is seen that in matrimonial proceedings, the interest of the child takes a backseat. In divorce proceedings, including divorce by mutual consent, the parties are so engrossed in their bitter fights that the welfare of their own child is lost sight of. It is here that the court must guide them. In mutual consent divorces, the parties settle all the terms and conditions before approaching the court, and we, as judges, seldom scrutinize those settlements. At times because we do not care, and at times with the thought that it may disturb the arrangement between the parties. However, in this rigmarole of thoughts, we miss the most important aspect of securing the future of the minor child by ensuring that a reasonable amount of maintenance has been kept aside for the child. Since Section 13 of the Guardians and Wards Act categorically stipulates that the welfare of the minor is the paramount consideration, therefore, it is also the paramount duty of the court to ensure that while parting ways, the parents have taken all due care to secure the future of the child and have a writing to that effect also, be it in the form of a gift, as pointed out by the Lordship, or in the form of a fixed deposit for the minor child, by creation of a trust for his benefit, a health insurance, or an insurance policy. There must be some means for securing the future of the child in the terms and conditions settled between the parents. In matrimonial matters, the financial conditions of the parents and their affluence must be considered, and it must be ensured that the amount left aside for the minor child is sufficient to cater to his future needs. It is also the duty of the court to verify about the self-acquired as well as ancestral properties of the parents and ensure that the share of the minor child in the said properties is secured in accordance with law. The interest of the child must be kept in consideration even if the mother is relinquishing her claim in the property of the father. Then we'll come to divorce by mutual consent. What are the requirements? Under Section 28 Special Marriage Act 1954, Section 32B of the Parsi Marriage and Divorce Act, Section 10A of the Indian Divorce Act 1869, and Section 13B Hindu Marriage Act 1955, a joint petition is required to be filed by the spouses. They must have been living separately for a period of 1 year. Though of course it is 2 years under the Indian Divorce Act. They have not been able to live together and they have mutually agreed that marriage should be dissolved. Living separately should be immediately preceding the petition of the divorce. Now, what is living separately? This has been explained by the Honorable Supreme Court in case titled Sureshta Devi versus Om Prakash, AIR 1992, Supreme Court 1904. So it has been observed that the expression living separately means not living like husband and wife. It has no reference to the place of living. The parties may live under the same roof by force of circumstances, and yet they may not be living as husband and wife. The parties may be living in different houses, and yet they could live as husband and wife. So what seems to be necessary is that they have no desire to perform marital obligations, and with that mental attitude, they have been living separately for a period of 1 year, immediately preceding the presentation of the petition. Now, there is waiver of the cooling off period. In a divorce by mutual consent, there is a period of waiting for 6 to 18 months. This interregnum was obviously intended to give time and opportunity to the parties to reflect on their move and seek advice from relations and friends. In this transitional period, one of the parties may have a second thought and change the mind not to proceed with the petition. In the landmark judgment of Amardeep Singh versus Harveen Kaur, 2017, Volume 8, SCC 746, it was observed that the cooling period of 6 months is not mandatory, but it is directory. It was held that as the period mentioned in Section 13B2 is not mandatory but directory, it will be open to the court to exercise its discretion in the facts and circumstances of each case. Where there is no possibility of parties resuming cohabitation and there are chances of alternative rehabilitation. So it is if a case is made out to waive the statutory period under Section 13B, subclause 2 of the court can do so after considering certain facts. I'll just enumerate those facts. First, the statutory period of 6 months specified in Section 13B, subclause 2, in addition to the statutory period of 1 year under Section 13B(1) of separation of parties is already over before the first motion itself. Second, all efforts for mediation or conciliation, including efforts in terms of Order 32A, Rule CPC, Section 23(2) of the Hindu Marriage Act, and Section 9 of the Family Courts Act to reunite the parties have failed. And there is no likelihood of success in that direction by any further effort. The parties have genuinely settled their differences, including alimony, custody of child, or any other pending issues between them. So these are the factors which have to be considered by the court before waiving of the cooling off period. And the last but not the least is the waiting period will only prolong the agony. So these are the factors which the courts have to consider. Otherwise, the cooling off period cannot be waived off. The waiver application can be filed 1 week after the first motion, giving reasons for the prayer for waiver. If the conditions mentioned hereinbefore are satisfied, the waiver of the waiting period for the second motion will be in the discretion of the court concerned. It has to be kept in mind that the object of cooling off period of 6 months before grant of decree of divorce is to safeguard against hurried decision if there is a possibility of reconciliation. So if the court is satisfied that there is no possibility of reconciliation, then it can go ahead. Object is not to perpetuate purposeless marriage or to prolong agony of parties where there are no chances of reconciliation. There's another case, Jai Shankar and another versus Nil, 2021, SCC Online, Madras 708, where the husband and wife had been living separately for 13 years. So there also, the relying upon Amardeep Singh's judgment, the cooling off period was waived off. Now it has to be remembered that the consent of the parties must be free. It should be free from force, fraud, or undue influence. In this regard, there's a citation, Anuradha Samir Venengot versus Mohandas Samir Venengot. May I request Mr. Malhotra to switch off the mic?
Sorry.
Thank you so much.
Sorry, thank you.
It's fine. The Honorable Apex Court, this is 2015, Volume 16, SCC 596. In this, the Honorable Apex Court has held in the fact, first I'll just give you the brief facts. The wife was suffering from cancer. She agreed to divorce by mutual consent in consideration of rupees 12.5 lakhs as full and final settlement from husband. So it was held that the instant case, it is the primary duty of the husband only to provide facilities for the treatment of the petitioner wife. This is pre-existing duty of the husband, provided the husband has sufficient means and he is diligently doing his part in taking care of her. By the settlement agreement, the respondent husband is promising to do something which he is already bound to do. Then it is not a valid consideration for the settlement. So here the consent was not free. Navdeep Kaur versus Mahinder Singh Ahluwalia. Here again, this is 2010, Volume 2, Marriage Law Journal, 400. Honorable Punjab and Haryana High Court has again discussed that the paramount thing which is required to be considered by the court is correctness of contents of the petition filed, and also to see that consent of either of the parties has not been obtained by way of force, fraud, or undue influence. In this case, the parties were appearing through attorney. So it has been, as a matter of caution, it has been stated that in the absence of the parties, where the attorney appears, the courts have to be more cautious and vigilant in recording its satisfaction about the consent. So now there are cases when the parties are absent, maybe in the second motion. So it is a settled legal position that consent cannot be presumed by the absence of the parties. In case titled Samriti Pahadia versus Sanjay Pahadia, 2009, Volume 13, SCC 338, Honorable Apex Court has held that consent cannot be presumed by the absence in court of one spouse at the end of 6 months cooling off period. Then in Ramola Mandir versus Charanjit Singh Mandir, 2015, Volume 3, Law Herald 2556. It was held that where one of the parties is absent during the course of second motion, the trial court should afford at least one opportunity to the party to appear for second motion before dismissing the joint petition, as the same is moved jointly by the parties under section 13B. Now, withdrawal of consent of the parties. The parties can withdraw their consent at any time. In case titled Avnish Sood versus Tithi Sood. The aspect was discussed. There was another case, Sarishta Devi versus Om Prakash. A party to the petition can unilaterally withdraw his consent at any time till passing of the divorce decree. If subsequent motion seeking divorce decree under subsection 2 is not of both the parties, because of withdrawal of consent by one of the parties, court gets no jurisdiction to pass the decree. The mutual consent should continue till passing of the decree. There's Anil Kumar Jain versus Maya Jain, where the Honorable Apex Court granted divorce under Article 142 Constitution of India, where the withdrawal of consent by one party, even expiry of statutory period of 6 months, was resulting in the petition. Now, in case Rajesh R. Nair versus Meera Babu, AIR 2014, Kerala 44. In this case, the issue that was raised was whether once a consent is given and later on it is withdrawn by one of the parties, can the court inquire into the bona fides or otherwise of the withdrawal of the said consent? The answer is no. It is not for the court to probe into the bona fides or reasonableness of withdrawal of consent. And once consent is withdrawn, the only option available to the courts is to close the matter at that stage. Now, there are cases where benefits have been received by the parties. Now, Deepak Singh versus Pooja, 2016, Volume 2, RCR 742. Honorable Punjab and Haryana High Court has held that if the party that receives money retracts from mutual consent, such a party would be required to restitute the amount so received. It is a duty is cast upon the court seized of such disputes to restore parties to the position on the date of filing the petition. Then there's another case, Ravinder Kumar versus Rekha Rani, 2016, 182, PLR 461. Here also the amount was received by the wife, but she retracted from making the second statement. So it was held that the amount which has been received by the appellant, consequence of the statements made at the first motion, is liable to be restored to the respondent. Where parties filed a petition for grant of divorce by mutual consent and recorded statements in first motion, and wife received certain amount, it was held that the aggrieved spouse cannot maintain an appeal against the dismissal order. The only remedy available is to file appropriate application before the district judge or the family court, as we have family courts now, praying for refund of alimony. So there's no provision of appeal. It is the application that has to be made in the same court. This was held in Vikas Verma versus Harpreet Kaur, 2016, Volume 1. Law Herald 688. Now, withdrawal of consent in second motion shall not attract contempt proceedings in every case. But if an agreement was executed between the parties or any undertaking was given in the court, any attempt to resile therefrom would amount to a breach of the undertaking accepted by the court and therefore attract contempt proceedings only if certain conditions stipulated in the agreement were agreed, acted and violated. Now I'll refer to Avnish Sood versus Tithi Sood again. This is 2012 SCC Online 2445. Here an MOU was executed wherein it was agreed that the parties will seek divorce. Thereafter the parties approached the court. As a one-time settlement, rupees 7 crores was to be paid. In the first motion, 1.5 crores was paid by the husband to the wife. But the wife did not come for making statement in the second motion, despite the undertaking given to the court. So it was held by the Honorable Delhi High Court that once the respondent has taken advantage of the agreement entered into, the terms of the settlement cannot be withdrawn by the respondent to suit his whims and fancies to the detriment of the petitioner. Here, the petitioner was held liable for civil contempt, the wife. Hirabai Bharucha versus Piroj Shah Bharucha, AIR 32/1945, Bombay 537. It was held that if a contract between the spouses recording the terms of settlement runs against the public policy, then it must be treated as void ab initio and unenforceable in law. In those circumstances, contempt proceedings cannot be resorted to. Then Shikha Bhatia versus Gaurav Bhatia and others, 178. This is 2011, DLT 144. Here the wife had filed an FIR against the husband. The husband filed the anticipatory bail application, and during pendency of that petition, a settlement was reached between the parties to the effect that parties will seek divorce by mutual consent. And the husband will pay rupees 8 lakhs to the wife at different stages, and all the pending cases between the parties will be withdrawn by both the parties. Acting on that settlement, the anticipatory bail was granted to the husband, and he also paid certain amount to the wife. Thereafter, the husband did not comply with the terms of the settlement, and the court held him guilty for contempt of court. The Honorable Court observed that the respondents, once having taken the advantage of the agreement, entered into the terms of the settlement, then they cannot be withdrawn by the respondent to suit his whims and fancies and to the detriment of the petitioner. There's another case, Prakash Alumal Kalandari versus Jahnavi Prakash Kalandari, AIR 2011, Bombay 119. Here it has been held, which we all know, that the consent to continue till the end. If the consent is withdrawn, the court is left with no jurisdiction to grant a divorce by mutual consent. If the petition is filed simpliciter under section 13B of the Act for Divorce by mutual consent, the court must satisfy itself that the consent given by the parties continues till the date of granting decree of divorce, even if one party unilaterally withdraws his or her consent. The court does not get jurisdiction to grant decree of divorce by mutual consent in view of the mandate of section 13B. However, the situation would be different if the parties in the first instance resort to petition for relief under section 9 or 13, and during the pendency of such petition, they decide to invite decree for divorce by mutual consent. On the basis of agreed arrangements, if the parties were to execute consent terms and then file a formal petition, in the latter proceedings before the decree is passed, one party cannot be allowed to unilaterally withdraw the consent if the other party has already acted upon the consent terms either wholly or in part to his or her detriment. So simple withdrawal of consent would not attract contempt, but the other conditions as mentioned In Dinesh Gulati versus Ranjana Gulati, MAT Act FC 70/2016, it was alleged in a divorce filed on the mutual consent that the wife was not cooperating with the husband. So in this case, suo motu contempt proceedings were initiated by the family court. It was held that a suo motu contempt proceedings neglects the mutuality aspect provided under Section 13B of the Act. And once the parties were unable to or did not wish to proceed with the agreement for mutual consent divorce, then the only recourse was to restore the original divorce petition. Now, whether the parties can record statements in second motion through attorney? Yes. This was held by Honorable Punjab and Haryana High Court in Jaspreet Kaur Dhaliwal versus Kulwinder Singh, Law Finder Document ID #749017, where the trial court did not doubt the bona fides. I'll repeat, did not doubt the bona fides of the parties or legality of the prayer. These conditions have to be satisfied for dissolution of marriage, to insist upon the personal presence of parties, particularly where parties admittedly residing abroad, would perpetuate injustice, wastage of time and money. In such circumstances, trial court should not insist upon personal presence of the party to record statement in second motion. Then in Rajwant Singh Bains versus Kulwant Kaur Bains, 2014, Volume 3, PLR 320. As per law, party in a divorce petition can appear through power of attorney or attorney who is also a relation to the party. Not otherwise, relation to the party. Statement can be recorded through power of attorney. Then in Amardeep Singh's case, courts have been permitted to use the medium of video conferencing in conducting such proceedings under Section 13B of Hindu Marriage Act. And even in this case, it was held that close relations such as parents or siblings, where the parties are unable to appear in person for any just and valid reason, as may satisfy the court, to advance in the interest of justice. So it has to be valid reason, not otherwise. Now there's another case, Santhini versus Vijay Venkatesh. Here the validity of proceedings conducted through video conferencing by the family court was taken into consideration. It was observed that the role of a counselor in family court is basically to find out what is the area of incompatibility between the spouses, whether the parties are under the influence of anybody or for that matter, addicted to anything which affects the normal family life. Even in the custody matters, the counselors assist the child if she is of such age to accept the reality of incompatibility between the parents, and yet make the child understand that the child is of both parents, and the child has a right to get the love and affection of both the parents. So it was observed that to what extent the confidence and confidentiality will be safeguarded and protected in video conferencing, particularly when efforts are taken by the counselors, welfare experts, and for that matter, the court itself for reconciliation, restitution of conjugal rights or dissolution of marriage, etc. So it is certainly difficult in video conferencing, if not impossible, to maintain confidentiality. It was also observed that the footage in video conferencing becomes part of the record, whereas the reconciliatory efforts taken by the duty holders referred in the judgment are not meant to be part of the record. So in reconciliatory efforts, physical presence of the parties would make a significant difference. So in this judgment, it was opined that the directions issued by the Honorable Court in Krishna Veni Nigam versus Harish Nigam needed reconsideration on the aspect of video conferencing, and therefore the matter was referred to larger bench for consideration. So the finding of larger bench is reported in 2018, Volume 1, SCC, page 1. So as per majority view, it was held that video conferencing in absence of consent of the other party would be contrary to Section 11 of the Family Courts Act. Physical presence of both parties in matrimonial proceedings held in camera is essential as it creates environment of trust, confidentiality, privacy, and emotional bond. Video conferencing at the first instance without consent of both parties would create a dent in settlement process and affect affirmative rights of dignity, privacy, and choice, particularly of women. Once settlement fails and when joint application is filed, or both parties filed their respective file memorandum for hearing of the case through video conferencing before family court, in that event, it may exercise its discretion to allow such prayer or after failure of settlement, if family court considers it appropriate, having regard to facts and circumstances of the case, that video conferencing would subserve cause of justice, it may so direct. The dissenting view came from Honorable Mr. Justice Chandrachud. It was held that video conferencing does not negate postulates of in-camera proceedings, even if such proceedings are desired by one of the parties. And it was observed that video conferencing is gender neutral and is capable of maintaining privacy. There's another case, Anjali Brahmwar Chauhan versus Naveen Chauhan, 2021, SCC Online, SC 38, where Honorable Supreme Court allowed video conferencing in matrimonial matters, but though not as a matter of course. It was observed, taking note of Santhani versus Vijay Venkatesh's case, which I just referred to here and before. It was observed that proceedings in all courts are being conducted only through video conferencing since March 2020, due to physical functioning of the courts having been stopped. Therefore, video conferencing can be resorted to, but not as a matter of course. So in Balwinder Singh versus Suman Rani, there are many cases in which in the first motion, in the consent, divorce by consent decrees, video conferencing has been allowed. So due to paucity of time, I'll just rush through. We'll talk about the Muslim law as well. In India, as per provisions of Section 2 of Muslim Personal Law, Shariat Application Act 1937, the Shariat law is made applicable to all Muslims for deciding their personal matters, which includes the matters of dissolution of Muslim marriage. The Shariat law is a comprehensive code of behavior that embraces both private and public activities of Muslims, and it also provides a complete judicial system. In case titled, the names have not been disclosed, 2021 SCC Online Kerala 2054, the jurisdiction of family courts has been upheld in deciding the matters of pertaining to talaq. Now, forms of divorce by consent under Muslim law are khulla and mubarak. Now, this has to be remembered that it is essentially an act of the parties and no intervention by the court is required in this case. The parties can come for a declaration if they so desire. I will not go into details of khulla and mubarak. The wife has right to seek dissolution of marriage under the provisions of the Dissolution of Muslim Marriages Act 1939. And after the enactment of the Muslim Women Protection of Right on Marriage Act 2019, the pronouncement of talaq at once is an offence in India. Now coming to the jurisdiction, Section 19 of Hindu Marriage Act stipulates, I'll not go into the details, stipulates the places where the divorce, where the parties can file the petition. The word resides must mean actual residence and not a legal or constructive residence. It certainly does not connote the place of origin. In order to give jurisdiction on the ground of residence, something more than a mere temporary stay is required. It must be more or less of a permanent character and of such a nature that the court in which the respondent is sued is his natural forum. This is Jivanti versus Kishan, 1982. लगाना जल्दी. Now there are cases where the child is living with the mother. So we have to see whether the child has been forcibly removed only to create the jurisdiction at a particular place, or the child was continuously living with the mother since long. So I'll cut short the judgments also, which I wanted to refer on this aspect. So there are other cases. There was another query with regard to proof of marriage. Haryana Compulsory Registration of Marriage Act 2008 makes it mandatory that the marriages should be every marriage that has been solemnized in the state of Haryana and Punjab to be registered irrespective of caste, religion or creed. Now registration certificate is the best proof of marriage. Marriage can be proved through photographs, invitation card or even by an affidavit. Now there was a query from the officers with regard to transgender marriages. The law has given basic right of companionship only, which should be consensual, free from the vice of deceit, force, coercion, and should not violate the fundamental rights of others. There is no acceptance of the institution of marriage between two individuals of same gender, either in personal law or codified statutory laws. In Arun Kumar and another versus the Inspector General of Registration and others, a marriage was solemnized between a trans woman, both professing Hindu religion. It was held that it is a valid marriage in terms of Section 5 of the Hindu Marriage Act. The registrar of marriage was bound to register the same. So due to paucity of time, I've just cut short the presentation. Now I'll request Mr. Anil Morodra to take over. Thank you so much.
A very good afternoon to you all. Honorable Justice Ritu Bari, my teacher, Dr. Balram K. Gupta, whom I affectionately address as Lord Denning, and legal guardians of families. At the outset, I'm very, very indebted and grateful to Honorable Justice Ritu Bari, who has, ever since the inception of the High Court, taken the step forward of reorienting the rules for the family courts. And I owe this training, I owe this discipline to the Karta of the Kopassanary of Judges, Justice A.L. Bari, father of Justice Ritu Bari, who continues to guide us in his ripe age of 90s and has always been a source of inspiration to me as a young lawyer who joined the bar in '85, and his path-breaking judgments on whatever jurisprudence he dealt with was always the guiding path for judges and lawyers. Now, before I enter into the arena of limping marriages, as I call them, which Satya versus Teja Singh identified 42 years ago in 1975, I pose some questions which I, as a mechanic with a toolbox, lug around all over the country and which have arisen to me. Now, every morning when I see for 5 newspapers I find in them scores of advertisements of substituted service, trying to serve erring spouses in Italy, in Germany, in Canada, in Sweden. And then every day I look at the CPC and I wonder to myself, why do we resort to Order 5, Rule 20, which talks of substituted service? Why have we not changed to Order 5, Rule 25, which came in after the judgment of the Supreme Court by Justice Sabharwal, where service was allowed by courier, by email, by fax, and other alternative means? My proposition is, when a marriage is limping, it needs to be resolved. When you pose a newspaper notice, it takes 3 months or 4 months before anything gets anywhere. And who is reading Tribune, Pioneer, or Chardi Kala in Italy, Germany, or France? So I seriously think that the High Court rules should incorporate a provision at par with Order 5, Rule 25, which says that where the defendant resides outside India and has no agent in India empowered to accept service, summons shall be delivered to him at the place where he is residing and sent to him by post or by courier or any method approved by the High Court, by fax or the electronic mail service, to be as the High Court rules may provide if there is postal communication between the place and institute outside. So we seriously need to change this concept, outmoded concept of substituted service by newspaper notices, because I honestly, to me, it's only a prolongation of a misery which doesn't serve any purpose. So this is one humble suggestion I have. The second glaring issue which I find often in limping marriages is a domestic violence petition cannot be filed in the family court because the jurisdiction is under the Prevention of Women from Domestic Violence Act 2005. But what happens if there is, let us say, in one court in Chandigarh or in Punjab or in Haryana, a domestic violence petition before a judicial magistrate and a same list between the husband and wife and the child in the family court? Can they be clubbed? The question has been taken by me recently to the Supreme Court, but this is an inconsistency which will need to be resolved at some point of time. The third issue which I find in limping marriages is that the spouse who comes to India, sometimes the woman, takes an interim custody order under Section 21 of the Prevention of Women from Domestic Violence Act. So the foreign court wants to know, is this remedy conclusive? The answer is in the Prevention of Women from Domestic Violence Act, because it says the independent remedy is available, and the substantive remedy is under the Guardian and Wards Act or the Hindu Marriage Act or the Special Marriage Act, as the case may be. The second is parents, spouses come complaining that the order of the family court has not been complied with. Is execution the only answer? Or does the power lie with the High Court to issue contempt under the Contempt of Courts Act? Because under the Contempt of Courts Act, Section 10 says that the High Court can take notice of the court's of contempt or violation of the subordinate courts also. But how many have been filed? How many have been entertained? So there is something in the rules which probably will need to cover this as well. Then another issue which probably can be addressed in the rules is, if there are interim orders passed by the family court which are not appealable under Section 19 of the Family Courts Act, how are they to be challenged? In Bombay, they are challenged by a writ petition under Article 227 of the Constitution. In our court, they are challenged under 227 and they are tabled as a civil division. So I think some nomenclature to define the challenge to the interim orders would be necessary, because under Section 19(4) of the Family Courts Act, interlocutory orders cannot be challenged under the Family Courts Act itself. Now, with this brief introduction, I now come to an area which I will speak minus judgments, because eminent speakers before me have led to you a rich knowledge, a data bank of citations on probably every aspect. So I would not wish to repeat, and I would not wish you to be burdened with more citations. I have circulated a concept paper in which I have given all the citations. My ninth book, Global Indian in the Law, contains a plethora of law, but I will talk to you about human beings, lives, because you are guardians of families. You are not family court judges. Your purpose, your laudable goal, your pious duty is to bring harmony into the home. And I'm very happy to see that there are such large number of energized young officers who are manning and donning these posts, and they are treating this as something of a conscientious duty which they must fulfill to achieve the lofty goals of the Family Courts Act. Now, guardians of families, we are a population of 1.3 billion. Now, approximately 30 million of us live in about 200 countries, and we are labeled as overseas citizens of India, persons of Indian origin, or plain and simple NRIs. India itself is spread over 3.28 million square kilometers to about 29 states and 7 union territories. And for me, as a mechanic with a toolbox going to a family court in Goa or in Chennai or in Bangalore, even that jurisdiction is alien to me. But it is the Family Courts Act which gives the umbrella, which is a central model to bring together a resolution dispute forum, which has come in late but still has been introduced in our jurisdictions. I would often find that there was a family court in Punjab or Haryana or in Chandigarh, but because it was not notified, the district judge was still referring matters to the subordinate judge, if it was the guardian and ward act petition, or a matter was going to the ADJ if it was a divorce petition. That resolution is, of course, taken place now. But then the biggest dilemma, which is now creeping up because irretrievable breakdown of marriage is not a ground for divorce, is what do you do with the foreign divorce decree which is before you? So I think we need to first understand the basic concept that once parties are Hindu by religion, irrespective of whether they are Germans, Canadians, Americans, Britishers, or Australians, they have a different passport, they have a different domicile, they will remain Hindus by religion. And the Hindu Marriage Act, Section 1 and 2 says that the Act has extraterritorial application. So this means irrespective of your domicile, irrespective of your nationality, irrespective of your citizenship, you will still be Hindu by religion. What does this effectively mean? So if you have a Hindu marriage solemnized under Section 7 of the Hindu Marriage Act by performance of Saptapati, and we all know registration is optional, it is a conclusive Hindu marriage for all intents and purposes. Now, the law laid down by the Supreme Court in Narasimha Rao's case is that Hindu marriages solemnized in India according to Hindu law can only be dissolved by a court of competent jurisdiction in India. Mirja Saraf's case went a little far to say that there should be a statute to this effect. But the fact of the matter is that this is a concept which has been explained further by Justice Rajiv Raina, whom I had the benefit of assisting as an amicus in Rupak Rathi versus Anita Chaudhary. Now, this was a case of a young couple from Haryana who had gone to the UK. The wife participated in the husband's petition for divorce by irretrievable breakdown of marriage. You all know irretrievable breakdown of marriage is not a ground for divorce in India. And at some point of time, she withdrew from the litigation and initiated a divorce petition in the family court, or it was a district judge at that time in Panchkula. The husband walked up with the matrimonial decree dissolving the marriage by a decree of divorce. In England, there is a decree nisi and there is a decree absolute. Decree nisi is granted for the asking. Decree absolute is made when you settle matrimonial property and custody of children. So when decree absolute was presented before the district judge in an application by the husband, claiming that the court had no jurisdiction because the marriage had been dissolved, the court dismissed the application and the matter came up in revision before the High Court. And the High Court expounded the principles laid down in Narasimha Rao's case. And the bottom line was, which is a very useful elucidation of the law, it says the validity of a marriage decree of divorce by a court of foreign jurisdiction will be tested on the anvil of section 13 and 14 CPC. So if any of the ingredients of a marriage under section 13 and 14 CPC is not satisfied or the exceptions fall in, then the decree is null and void. So the straight answer is, if it is a decree of divorce on irretrievable breakdown of marriage, it is no good, it does not serve any purpose, and the court is bound to reject the decree of divorce. What next? So the answer is, if an application under Order 7, Rule 11 CPC is presented to you, seeking to dissolve the marriage on the preliminary ground of maintainability, you are free to reject it, saying it is not a valid marriage. And then what do? You will have your own pleadings. You will have your own substantive petition. You will have the evidence. You will coin issues and you will decide. And the foreign decree may be one part of your conclusive decision if you wish to go into on merits. Now, on another note, which I will address tomorrow, is the procedure which a family court ought to adopt in a matrimonial proceeding or a guardianship proceeding. And this has been expounded by the Supreme Court by Justice Khanwilkar in a brilliant, illuminating judgment where I had the opportunity to assist the Supreme Court on what should be the procedure in a family court. That we will take up tomorrow. But coming back to the discussion. So you as the family court, under section 12 and section 14, I would very, in a nutshell way put, you are the Chief Justice of your own court. After you comply with the substantive procedure of the Family Courts Act, the Hindu Marriage Act, or the Guardian and Wards Act, you are free to devise your own procedure on what you have to do, on how you will handle the proceedings before your court. I've had the opportunity of conducting some matters in Delhi, where I find that the family court judges with seniority and age and experience have come out with very illuminating ways and methods of recording evidence, of coming down to issues, taking documents not admissible under law of evidence, breaking away from the shackles of procedure. And I think one way of breaking away from CPC is the substituted service. You are free to adopt an email, which of course is an option available to you under CPC also. But my humble suggestion to you as a practitioner, because I'm perhaps the only person amongst you all who's on the other side of the fence, is please decide expeditiously. Please decide whatever you think is right or wrong. You lay down the law. Supreme Court does not lay down the law. Supreme Court will only affirm or reverse what you will lay down as the law. So you are the makers of law. Unless you apply your mind, unless you think in an innovative way, you think out of the box, which liberty is given to you under section 12 and section 14, we will not be able to evolve law. The pandemic in 2 years has multiplied and there is an explosion of family law litigation. I happened to do a webinar with Justice Hema Kohli and Justice Alistair MacDonald of the High Court of London, of the Family Division. And the view was unanimous that COVID has taught us to come up with new measures in new times. We have to cull out methods whereby we can put limping, we can dissolve limping marriages, or we can put together spouses in limping marriages. So in this larger perspective, I have seen two developments which have taken place in the Maharashtra jurisdiction, particularly the Bombay Family Court in Bandra, where there are 15 judges in one building. The principal judge has 14 additional judges, and he has appointed child independent lawyers to assist him in proceedings wherever there is a child. Because every litigation between spouses of parents for child custody is treated as a divorce petition. It is more of a battle of contest of the rights of parties. Who looks at the child? Nobody. So there is a voice of the child, there is a right of the child to be heard, and who projects it? Child independent lawyer. So if using this facility which is provided under the Family Courts Act itself, under Section 12 and Section 13, to have an amicus, I am free and available to any family court to assist as an amicus online whenever anybody needs me. But please do try and generate a breed of amicus lawyers to assist you in your jurisdictions. Among the younger generation, there is a bright spark of lawyers as well who will be able to assist you. And if you can build up some specialist family law lawyers in your jurisdiction to assist you, limping marriages can be dissolved in a more amicable way. Now, let's get the bull by the horns. What do we do with foreign decrees, and what do we do with jurisdiction of foreign courts and family matters is the topic which I have been asked to address. Now, the problems which I am asked to answer in view of an expert report as an expert evidence in foreign jurisdictions is, what is the validity of a foreign divorce decree? I am often instructed by spouses to ask, I have a Hindu marriage and I have an American civil marriage. Where do I file a divorce? I have property in both jurisdictions. How will we dissolve property? Are child rights decided in one jurisdiction conclusive in India? Now, these are questions which come because 30 million people have moved up and down and have habited foreign countries. The sad part is they don't want to start litigation in India because everybody thinks it's going to take very long. I often tell them, you need to find a method out of the box. We can solve the problem. So let us suppose you have a marriage which is broken down and in which there is a foreign divorce decree. Now, to the extent the foreign divorce decree dissolves the marriage if one has taken place in the US by civil rights, that dissolution of marriage is good for that civil ceremony. Insofar the Indian marriage is concerned, it has to be dissolved in India by a court of competent jurisdiction. Now, the nitty-gritty is, how do we do this? Law has developed. Justice Ritu Bari very well pointed out that the High Court has not only permitted dissolution of marriages online, it has also permitted registration of marriages online. I think we are probably going to expand in this jurisdiction with this enlightened view, and Justice Ritu Bari heading the Family Court Committee, where we will have a new set of propositions coming forth. So the advice given to parties is, you are still going to be married in India. So what is the answer? The parties turn around and say, there is one petition under the Domestic Violence Act. There is one petition under 125 CRPC. There is also an FIR under the 406-498A with the Dowry Prohibition Act. There is also a guardianship petition. So there are, let us say, 5 or 6 litigations which are pending in India. They will not come to an end if you dissolve the marriage. So the consensus advice to the parties is, you draw up a settlement in the US court, laying down what your marriage has in India to be dissolved. And after the dissolution of the marriage, subject to whatever happens in India, keeping back separation of matrimonial property and child custody issues at abeyance, so that pressure is there to resolve in India. You don't come to India, as Justice Ritu Bari very well pointed out. You can apply for a divorce online. You appoint your father, brother, mother, or any family member as your GPA. The GPA appears before the Honorable Court, identifies you, you sit in the foreign jurisdiction and hold your passport. You are identified as the same person. Both spouses appear through different counsel or the same counsel in a 13B petition. First motion is recorded. The second motion may be waived or not. I will come to that in a little while. And the foreign settlement between the spouses can be treated as the terms of settlement before the Indian court, and ultimately the dissolution of marriage under the Hindu Marriage Act in your court, let us say, that settlement will form part of the proceedings and be read as a conclusive settlement to dissolve the Hindu marriage according to Hindu law, so that parties are treated to be divorced in India also. This will free them of bigamy, because there are often cases where a marriage is disrupted because it is only dissolved in the US and it has not been dissolved. So if police walks into the second marriage ceremony and says this marriage is to be stopped, such kind of a situation can be obviated. Settlement of matrimonial property in India can be sorted out. Child custody rights can be sorted out. Child custody is the worst litigation which spouses take on to take revenge against each other, not realizing the irreversible damage they do to the child. So to put a full stop to the child custody litigation, it should be decided. There should be a parenting plan. There should be shared custody. There should be joint custody, or there should be singular custody. Whatever parties agree to, the matter should be solemnized, sorted out conclusively at that stage only, so that there is not another fresh round of litigation. Now, the Supreme Court has recently come up with a judgment in which they say that there is concurrent jurisdiction. So if there is a couple sitting in the US and there is a couple sitting in India, and they have moved permanently, domicile may be there, the court in the US has concurrent jurisdiction. But earlier, the view which was taken on domicile in Sundar Gopal's case was that the permanent domicile jurisdiction remains with India. So Supreme Court has a varying concept, but the fact of the matter is, as far as India is concerned, whatever arises within your jurisdiction, and Section 19 is very liberal to you in terms of accommodating a petition, particularly once there is a 13B settlement, which is arising between the parties. So with this broad perspective, I think what is very important in foreign decrees is that they can be resolved without going into a controversy of their being valid or their being invalid, because that is a procedural aspect which acquires no sentiment. Now, the question is, what happens if there are parallel proceedings between two jurisdictions? Now, this has become a very litigated area, because the moment one spouse in Australia faces an uncomfortable litigation, he runs and comes to Mumbai and files another petition. Then the spouse in Australia comes running and starts a new category of suits, which are probably not very well known in this part of the country. These are called anti-injunction suits. Now, under Section 7 of the Family Courts Act, the proceeding for a suit or proceeding for an order or an injunction in the circumstances arising out of a marital relationship are within the purview of Section 7. Now, I happen to take an objection in the Delhi High Court in a matter where an anti-injunction suit was passed seeking restraint of the father to proceed with the family court proceedings in Delhi on the ground that proceedings were pending in the US. I took an objection before the High Court that this anti-injunction suit has to go to the family court because the High Court has no jurisdiction. Delhi itself, the suit was filed in the Delhi High Court because Delhi High Court is a High Court of original jurisdiction. we are not in Punjab and Haryana. Bombay, Calcutta, Delhi are suits of original jurisdiction. So the objection taken by the council was that it is a suit for injunction, not an anti-suit injunction. So Justice Manmohan interpreted it by referring to a full bench that an anti-suit injunction is a part of a suit for injunction. So the anti-suit injunction concept, which came from commercial matters, is now used in family law matters to say that between the same parties on the same dispute, the same list, two proceedings ought not to go on. And the principle of comity of courts and principle of forum convenience demands that the litigation should go on in one forum only. Now, the court in India or court abroad cannot stop each other. But the court in India and the court abroad can stop the parties before them who are same in the litigation in the other jurisdiction, not to pursue the litigation in that jurisdiction. So such type of suits are known as anti-injunction suits. So anti-injunction suits are now a common parlance because litigation is sought to be stopped. An anti-injunction is very difficult to obtain because convincing the court of the jurisdiction is a difficult task. Foreign courts tend to grant the anti-injunction more liberally. Sometimes when parties don't stop or courts don't agree, the fate is sometimes sad because there are conflicting decisions. Normally, if a court is told that the matter has reached a substantial stage, it does stop initially, but sometimes court do not agree. Now, here I wish to pause on an aspect, and I wish to develop the concept which Justice Bari raised in the beginning of counseling and counselors in the beginning. It is very important that the marriage should be sought to be resolved at a stage before it becomes ugly. In Bombay, the matter does not go before the judge till the counseling has taken place before the counselor and a report is received that the counseling has failed. Now, in Perry Consagra, Justice Lalit has authored a beautiful judgment saying that the reasons for the counseling having failed need not be recorded, but they have to be disclosed to the court so that the court can evaluate as to what went wrong. So if we were to have a counseling through expert counselors assisting the court, like we have the mediators in the High Court, where we have trained an entire set of very strong and eminent lawyers to assist the courts, maybe the infrastructure developing in your jurisdiction independently. It's up to you I can imagine your limited resources, but maybe if the High Court were to assist with the counselors being made available to you, you would probably be better equipped in finding your feet in this issue. Now, the next issue is that how do you resolve property disputes and child custody matters in limping marriages? Now, as far as the law on children is concerned, insofar limping marriages are concerned, our Supreme Court has very clearly said child rights are never conclusive. Factors change, circumstances may differ, parties may remarry. Children are never bound in a straitjacket as far as child rights are concerned. So, even if there is a settlement, your conscience is pricked, feel free to devise methods for changing the custody issues of children. I will develop this concept of shared parenting and joint custody tomorrow in this perspective because it's a very important issue which needs to be addressed. The second issue in limping marriages come on access to children. The spouse or the parent who has a child in India in a marriage in which there is an issue deprives the other parent. So it is up to you to find ways and means. If there is a maintenance issue, stop the maintenance, do a barter, do a trade. Some resolution has to be found on the issue or as far as this is concerned. Likewise comes settlement of matrimonial property. Now, overseas, the settlement of matrimonial property is done by a 50-50 rule. Whatever is earned before marriage, whatever is earned during marriage is all split 50-50. So you have men often coming down to India to do divorces in India because they think they will have to pay less. Because we have a need-based maintenance law. We have to satisfy what is our requirement, what is our need, and according to the proportionate need, the maintenance is awarded. Now, there are situations when the spouse is earning, the maintenance is reduced down. Now, in this circumstance, a block settlement of a lump sum alimony is the best proposition, and the Supreme Court obviously endorses this process also and comes to a consensus on this issue. Now, coming to the issue of second motion, which I left there. Now, I have in my paper addressed this issue. Supreme Court in Amardeep Singh versus Harveen Kaur 2017, Supreme Court 4417 has said, we have no power under 142 to dissolve a marriage on the ground of irretrievable breakdown of marriage. The power is under 13B, and the Supreme Court says that the provisions in 13B are not mandatory, they are only directory. So the Supreme Court says, for waiver under section 13B2 and for the 6 months, Article 142 is not to be enforced. It is directory and not mandatory. It is a discretion of the family court to decide how you have to deal with this period. So if you find a matrimonial relationship has broken down, as I now see brilliant judgments coming from the appellate bench of Justice Tubari, that where a marriage is over, there's no point in keeping it alive. There is no need to force compatibility, cohabitation between parties. So if parties have gone apart from the very first day of marriage and 10 years have elapsed, I think 13B is the ideal example to apply. But then what is the status of the condonation period? Do you have to wait for 6 months for the same motion? Now, this is a discretion for you to exercise. If there is a motion in the application, in the joint petition, that we have been living apart for a year already, or more than a year, or more than 5 years, we have already dissolved the marriage, I think that 6 months period ought to be condoned. Now, there is no straitjacket formula. There is no hard and fast rule. You, as the judge of your own court, you as the legal guardian of the family, have to come to a conclusion how you will treat this, and it is up to you to decide whether you wish to condone the period or not. If you think there is a chance of saving the marriage, some relationship exists, fine. Now, there is a divide. As Justice Ritu Bari very rightly put it, every demographical jurisdiction differs on its needs, its requirements. You have a social strata under the poverty line. You have a social strata of earning groups. You have a high profile strata of double income groups in foreign jurisdictions. You cannot have a hard and fast rule for every category applying the same rule to all of them. Now, jurisdictions like Andhra Pradesh, where there are two independently earning spouses and the woman sometimes earning more, people often draw up a prenuptial contract before they leave India because they do not want to get into an ugly mess. But that is an elite requirement, and that is an argument of an exclusive category which will not apply to people. So where you find that the spouse is handicapped on account of lack of funds or resources, I think you're invoking the Legal Services Authority, which is now in existence in every jurisdiction, in every district, to provide a counsel free of cost to the concerned party can be the aim. And I think in such a situation, your requirement of deciding a Section 24 application for maintenance and litigation expenses should be a priority before deciding any other ancillary issue, because the question is only if there is going to be sustenance, be it 125, be it 24, or be the Divi Act, can the litigation carry on. So whichever party is at a distress in a limping marriage, I think ought to need the redressal on this issue. So with this overview, I come to an end. I only wish I could answer questions, but that is of course not possible. Maybe when Lord Denning decides to do a physical conference, wholeheartedly with the guidance of Justice Bari, we will be able to exchange views and thoughts and have a dialogue to exchange views and learn from each other. Thank you very much.